Could we just briefly review the layers of protection that you think exists? And I'm going to start with what the D.C. Circuit said. So the first layer of protection is that attorneys general and other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
How robust is that protection? I mean, most of the vast majority of attorneys general and Justice Department attorneys, and we both served in the Justice Department for a long time, are honorable people, and they take their professional ethical responsibilities seriously. But there have been exceptions, right? Both among attorneys general and among federal prosecutors.
There have been rare exceptions, Justice Alito, but when we're talking about layers of protection, I do think this is the starting point. And if the court has concerns about the robustness of it, I would suggest looking at the charges in this case.
Well, I want to talk about this in the abstract, because what is before us, of course, does involve this particular case, which is immensely important. But whatever we decide is going to apply to all future presidents. So as for attorneys general, there have been two who were convicted of criminal offenses while in office. There were others. A. Mitchell Palmer's one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are two officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the Department of Justice functions in the way that it is supposed to. Petitioner is alleged to have tried to get the Department of Justice to send fraudulent letters to the states to get them to reverse electoral results.
Yeah, I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand juries will shield former presidents from unwarranted indictments. How much protection is that?
Well, it affords two levels of protection. One is the probable cause finding requires evidence. I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting gate.
I mean, there's the old saw about indicting a ham sandwich.
Yes, but I think Justice
you had a lot of experience in the Justice Department. You come across a lot of cases where the U.S. attorney or another federal prosecutor really wanted to indict a case and the grand jury refused to do so.
There are such cases. Yes. But I think that the other level
once in a while there's an eclipse, too.
Well, I think that's for the most reason is prosecutors have no incentive to bring a case to a grand jury and secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right, then the third level is that former presidents enjoy all the protections afforded all criminal defendants, right? And we've discussed that. And that may be true at the end of the day, but a lot can happen between the time when an indictment is returned and the time when the former president finally gets a vindication, perhaps on appeal. Isn't that correct?
It is correct, Justice Alito, but I think that we should also consider the history of this country. As members of the court have observed, it's baked into the Constitution that any president knows that they are exposed to potential criminal prosecution. My friend says after impeachment and conviction, we don't read the impeachment judgment clause that way, but it's common ground that all former presidents have known that they could be indicted and convicted. And Watergate cemented that understanding. The Watergate smoking gun tape involved President Nixon and H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation.
I mean, Mr. Sauer and others have identified events in the past where presidents have engaged in conduct that might have been charged as a federal crime. And you say, well, no, that's not really true. This is page 42 of your brief. So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? Couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes, given this court's decision in Trump versus United States, in which Trump versus Hawaii, where the court said Korematsu is overruled. I mean, President Roosevelt made that decision with the advice of his Attorney General. That's a layer of safeguard.
Is that really true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
So I think that there is a lot of historical controversy, but it underscores that occurred during wartime. It implicates potential commander-in-chief concerns about the exigencies of national defense that might provide an as-applied Article II challenge at the time. I'm not suggesting today, but the idea that a decision that was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Lanier that the right have been made specific so that there is notice to the president. I don't think that would have been satisfied.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the Attorney General that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once-in-history prosecution.